My Lord, I would like to seek your Lordship indulgence in making a mention of item number 8. My Lord, I'm for the respondent number 1. The other day, one advocate is inquiring about this particular case. I thought that I was going to be replaced by him. So I need some time to consult with my clients whether I'm still there or I'm going to be replaced by.
No objection, my lord.
How much time you require?
Maybe listed after the coming vacation, my Lord.
Okay, Mr. H. Gantry, my learned senior counsel appearing for the respondent number
Number
one.
1, yes, my Lord.
Submits that he needs to take up to the instructions from his client
My Lord.
and therefore prays that the matter be posted again after the ensuing puja vacation.
My Lord.
Stop. Mr. Victor L. Ralte, learned counsel for the appellant, has no objection to the prayer. Yes, appellants. In view of above, matter stands adjourned to be listed again after the puja vacation.
Obliged.
My lord, in respect of item number 10, hearing list, this CRP number 1 of 2022, they are challenging the Lok Adalat award in this case, which is in connection with civil suit number 6 of 2009, wherein your lordship had some involvement in the connected civil suit.
Item 10.
Item 10.
So may come up before any
Yes, my
other
lord.
bench.
Yes, my lord.
List this matter before any other bench without me. Just put my name in the bracket. Yes.
I seek your lordship's indulgence in mentioning hearing item number 11. Miss H. Malswamy has requested me to adjourn this matter for some time.
Why was the difficulty? What is the difficulty?
She's in maternity leave, my lord.
She could have appeared on via VC. I think she appeared also the other day.
Yes, my lord.
How much time?
After vacation.
Mr. Malhotra?
It's okay, Your Worship.
Okay. Miss Caroline K. Lungoipui makes a mention on behalf of Miss H. Lal Malswamy, learned government advocate appearing for the state respondents, and submits that since Miss H. Lal Malswamy is on maternity leave, the matter may be posted again after the ensuing vacation. Stop. Mr. A. Malhotra, learned counsel appearing for the appellant, has no objection to the prayer. Stop. In view of above, this is the matter again after the ensuing puja vacation.
I'm obliged.
May I seek your lordship indulgence in making a mention with respect to part 1, item number 9, lordship.
This is the only one which was left for hearing. What do you want? You are for which party?
I'm for the appellant, lordship.
No, there's no appeal. This is a writ petition. Item 9, isn't it?
Item number 9. lordship.
This is a writ petition. So you must be for
sorry,
the
Lordship.
petitioners.
Yes, petitioner, lordship.
Yes. What do you want?
Lordship, if this matter may be listed after a week or as per the convenience of the court, lordship.
What is the difficulty?
Because, lordship, my senior, he has some difficulties, personal difficulties in appearing today, lordship.
Okay. What about the other side? Have you informed them?
Yes, lordship, I have taken the consent from the other party, lordship.
What is your good name?
Rosie Manlomsangi, lordship.
Rosie
Manlomsangi.
Mallomsangi.
Yes, lordship.
Miss Rosie Mallomsangi, learned counsel, submits that she is led by Mr. Joseph L. Rentle, learned counsel in the case for the petitioners. Who is for the petitioners? And she submits that as Mr. Joseph has some personal difficulties to conduct the case today, the matter may be adjourned. In view of above, and as prayed for, matter stands adjourned for a week.
Yes, lordship.
Yes.
Obliged.
For motion, item number 1.
Yes, Mr. Ramzal.
Lordship, before anything is said, may I take a Lordship to para 10 at page 10, where I have committed a mistake, seeking the correction. In para 10, it is stated that in the interest seniority list of assistant grade 2 under respondent number 1 and 2 was provisionally fixed as on 31/1/2024, in which the petition has been shown at serial number 1. Instead of 1, it has to be 3, Your Lordship. This is a typographical mistake committed. If Your Lordship permits correction, this is instead of 1, it may be taken as 3.
Only this.
Only that, yes.
Prayer portion remains okay.
Prayer portion remains same.
Who's for the other side?
I will be appearing for the respondent number 1 and 2. The
One.
Apex Bank. 1 and 2.
Apex Bank.
Yes. Chairman and CEO.
You are engaged specifically for this case or as standing
No, I'm
counsel?
a standing counsel.
Standing counsel.
Standing counsel. I will have to file my vakalat nama by tomorrow. They have given me advance copy of this writ petition.
You are standing counsel.
Yes, my lord.
So it may be corrected then.
Yes, Lordship. I'm
You
applying.
corrected just now.
Yes.
Then give your signature.
No problem.
You correct in the copy given to the other side also.
Para 10 more. 1, 3. Walang pangkukunan pa. Second copy also. Second copy also. 1 higher country.
Yes, surely. Second copy. And all the copies.
Page 10. Cut drop now. Lordship, this matter pertains to supersession of the petitioner in respect of promotion from assistant grade to JMG. A similar case was earlier decided by this honorable court in connection with the WPC number 55 of 2006. In which the petitioner was AG2 in the Apex Bank. He was employed as such, and then he was superseded by his juniors. And then the case was filed, and Lordship, the matter was decided by this honorable court. Lordship, the substance of the decision which is rendered in connection with that particular case is that in a matter in which the promotion is based on seniority, not on merit, if the candidate is eligible for promotion, even if he is having a score less than that of the score of his juniors, then he needs to be given the promotion because it is in the line of seniority.
So you mean to say the promotion from AG to JMG is on solely on the basis of seniority?
There are two channels. One is merit cum seniority channel. We are not in merit cum seniority channel. We are in the seniority channel only.
Where is that provision?
The provision is
There's no dispute regarding your seniority position over the private respondents.
so far as the respondent number 4 is concerned, she is senior to us. senior to me.
Then,
But the reason why she has been implemented is that she was considered, in spite of the fact that her SCR was considered after the period where it is when it was no longer permissible. The SCR for the period from 21-22 was considered by the selection committee, though it was not permissible at that point of time.
but how can you say that?
I had taken the stand in
That
my
in-
representation also.
That information is available to you. How is it available
It's
to
a personal information, Your Lordship. Because she was working in the same bank and she did not submit her SCR during that period. And after completion of the period, only 3 months is allowed for submission of the SCR. And the SCR of that particular year was submitted after a year. After a year. And I had made a complaint to that effect
you? The ACR was submitted belatedly
belatedly.
and it was considered.
It was considered.
It is not that ACR which was not supposed to be considered has been considered. That means of different year.
No.
The years were relevant.
Yes, was
The years were relevant. Only thing is that it was a belated submission.
belated submission.
So they could not have
Yes,
considered that.
when it was already
Then
barred by the provision of law.
you said you submitted representation.
Yes,
What happened to that?
nothing was, no positive response was made by the bank.
So that is why you have made her a party here.
We have made her party, though she is senior to the petitioner.
Though she is senior to the petitioner, but the fact that her ACR, which was not supposed to be considered, has been considered.
Right.
That is why you made her a party.
That's true.
And as far as respondent number 3 is concerned,
Respondent number 3 is junior to me,
he is junior to you.
junior to me.
Now, show us where is that provision which says that there are 2 channels. One is seniority cum merit and one is only seniority.
Your Lordship,
It's in the bylaws or something.
it's in the rules, staff service rules 2024.
You could have abstracted the relevant portion in the writ petition.
In fact, Lordship, I have extracted it.
What is this? Staff Service Amendment Rules,
Yes, Staff
2024.
Service Amendment Rules 2024.
Amendment Rules 24.
Amendment Rules, yes.
Is this relevant?
Yes, Your Lordship.
Amendment. Promotion happened on
In 2024,
July.
July.
And this amendment is effective from
It's from 22nd January 2024. 22nd January 2024.
how do you say that? From where?
From page 1,
Page 1.
the extent clause. Rules shall come into force with effect from 22nd January 2024.
Page 1. I have not seen that. Mr. Ramzawa, where is that? Page 1, you say?
Page 1. Page 1.
Page 1 is the preliminary stuff, chapter 1. This page.
Page 1. Chapter 1.
Subrule 2 of Rule 1. Is it?
Subrule 2
Rule 1.
of Rule 1. Yes.
22
yes,
1
yes,
2024. Okay.
yes.
So now you show me what is the provision
Now, provision is at Appendix 4
that is at page.
at page 113.
Appendix 4113. Yes.
It consists of two channels. Channel A is merit cum seniority.
And channel B, seniority, performance,
Channel
etc.
B is at 114.
But it's not,
Seniority, performance.
it also says performance.
Yes, performance also there. Seniority, performance.
Merit comes seniority. Merit also includes performance, isn't it?
Performance, yes, Lordship. Under Rule 23, Rule 23(7), Lordship, if Lordship turns to page 25, page 25 is rules relating to promotion. And the distribution of marks is there under Rule 23, subclause 7. Distribution of marks in examination, interview, etc.
Yes. This is for which method?
This is for general. This is general, where there is written test, 100 marks will be carried by the written marks. But in respect of seniority channel, only this performance, seniority, and interview. That will be the three considerations.
Where do you get that?
At page 27, Lordship, channel B.
Channel, okay, channel B.
Wherein it is stated.
Performance, seniority, interview.
Yes, these are the three yardsticks.
Performance 45, seniority 20, interview 35.
Yes.
So seniority is just 20.
Seniority 20.
Performance is still required.
Performance is required
Which is at
for the
45.
purpose of securing the minimum qualifying marks.
Sorry?
For the purpose of securing minimum marks, minimum qualifying marks. Under subclause 8, just below the channel B, Lordship will see minimum qualifying marks to be considered for promotion will be 50% of aggregate. Selection shall be done on the basis of combined marks of written test, performance, seniority, and interview. This is what has been followed.
50% of aggregate means 50% of 45,
20.
50% of 20, 50% of 35.
Yes, yes,
But that will be qualifying marks.
qualifying marks.
And who is to be selected
On the
will
basis
be,
of,
will be the candidate who scores the most.
that is according to the interpretation of these rules. But as per the interpretation made by this honorable court in the other case, in the earlier case, once a candidate attains the minimum qualifying marks, it is no longer possible or necessary to make selection on the basis of aggregate marks or the marks obtained if it is under seniority channel.
And that case was the interpretation of which rule?
Of the earlier rules, earlier rules,
Unamended. Unamended.
1995 rules. The principle remains the same, Your Lordship.
No, but this has been amended.
This has been amended, but the principle is still followed.
You are in the presence of the amended rules which provides for such kind of criteria.
Yes, yes, that's true. Your Lordship, in order to
without challenging the same, how do you proceed?
in order to dispel the doubts which may be created because of the provisions in the SSR 2024 and even
The earlier rules is 1995.
1995, thereafter 2011,
So-
and after that 2020.
20 also.
Yes,
So the repeal and saving clause is at 109, which says staff service rules 83, 95, 2011 are hereby repealed.
yes.
But that 2020, what is that? It is not available here.
2020 has not been repealed, it seems. Nothing
not repealed.
is mentioned.
So the judgment which you are relying upon was a judgment in
Made
respect of
in
the
the
1995 rules.
1995, yes.
Now,
Lordship,
after the amendment, then
If I take Lordship to the judgment which has been rendered by this honorable court, it is, to my understanding, it is squarely applicable at page 29, Your Lordship.
yes.
Page 29, para 1, when seniority cum merit is the criterion for promotion provided in the rules, can a senior who has obtained requisite benchmarks be superseded by his juniors on ground of superior merit? Is the solitary question for decision of this court in the present case. I have heard the learned counsels. The factual metrics. First, the petitioner is working as assistant grade 2 in service of Mizoram Cooperative Apex Bank Limited and eligible for promotion to assistant grade 1. It is not in dispute that all the 14 private respondents who have been promoted to assistant grade 1, respondent number 18 and 19, who have been shown in the promotion panel on selection by impugned notification dated 29/8/2005, are juniors to the petitioner in the assistant grade 2. The inter-seniority list of the incumbents in assistant grade 2 showing their position as on 15/9/1998 in the notification dated 19/9/98 is also not in dispute. Petitioner is in serial number 5, while all the 16 private respondents are below him in the said seniority list. The rules governing promotions of the officers and staffs of the said bank have been provided in the staff selection rules as amended in 1995. According to the said rules, promotion is the only source and a mode of selection of incumbents in assistant grade 2 for promotion to assistant grade 1 is seniority cum merit, known as seniority channel. The relevant provisions appearing in Appendix 3 of the said rules, being relevant for disposal of the present controversy, may be noticed at this stage. It is quoted here, Lordship. Promotion from assistant grade 2, grade 1, seniority channel. 1. An employee in the assistant grade 2 having rendered confirmed continuous satisfactory service in grade 2 for 6 years will be eligible for promotion to grade 1 through seniority channel. Mode of selection, seniority and performance on a basis of marks allotted against its criteria. Seniority 20 marks, performance 20 marks, interview 10 marks, and the total is 50. Marks will be awarded in the following manner. Service seniority for every completed year of service will get 1 mark up to 10 marks, and beyond which 2 marks for every completed year of service with a maximum of 20 marks. Performance, for records of service in the assistant grade 2, candidate will get marks as follows. Average 5 marks, above average 10 marks, good 15 marks, excellent 20 marks. Qualifying marks to be considered for promotion will be 50% of the aggregate marks. It would be seen from the above that 25 marks in aggregate shall be the benchmark. The requisite merit for promotion to assistant grade 1. That is the requisite merit for promotion to assistant grade 1. A backward journey would show that the petitioner was earlier promoted to assistant grade along with 14 others on seniority cum merit basis by notification so and so, his position being at serial number 9 of the promotion list, but the said promotion was assailed in writ petition number 49 of 2004 by R. Zabanglova, the 8th respondent herein. That writ petition, along with another writ petition number 48 of 2004, which relates to promotion from middle management grade 1 to senior management grade 2, was disposed of by this court on 23/6/2005, setting aside all the promotions on the ground that the selection committee acted contrary to the provisions of the relevant rules. The bank management was directed to undertake the process of selection afresh by considering the cases of all eligible candidates within the zone of consideration on the basis of the provision contained in 1995 rules and in terms of employment notice dated 9/10/2003. Following the decisions of Lordship, I'm just reading on, because,
You may come to the operative portion
Right.
straight away.
if I take a Lordship to para 6, at page 34, Lordship. Bearing in mind this perception of the bank respondent set out above, the true meaning of the seniority cum merit principle need to be correctly understood. The Apex Court had occasions to decide similar issue and noted that while the principle of seniority cum merit lays greater emphasis on seniority, merit cum seniority laid greater emphasis on merit and ability, and seniority plays less significant role. In AB so-and-so, reported 1998, 6 SCC 720, which has been followed in Hari Govind, Yadav versus Rewa City, Grameen Bank and others, reported in 2006, 6 SCC. The Supreme Court observed in para 18. We thus arrive at this conclusion that the criterion of seniority cum merit in a matter of promotion postulates that given the minimum necessary merit requisite for efficiency of administration, the senior, even though less meritorious, shall have priority, and a comparative assessment of merit is not required to be made. For assessing the minimum necessary merit, the competent authority can lay down the minimum standard that is required, and also prescribe the mode of assessment of merit of the employee who is eligible for consideration for promotion. Such assessment can be made by assigning marks on the basis of appraisal of performance, on the basis of service record, and interview, and prescribing the minimum marks which would entitle a person to be promoted on the basis of seniority cum merit. It would be seen that in Hari Govind Yadav Supra, the Supreme Court further observed that minimum necessary merit can only be assessed by the bank through interviews. Once the senior incumbents are found to have the minimum necessary merit, selection thereafter for promotion with reference to comparative marks is contrary to the rule of seniority cum merit. Lordship. Para 7. Following the above decision of the Apex Court, this court in Ranjit Kumar, Roy, and others versus Tripura Grameen Bank reported in 2006, 1 GLT 553, held in Para 6. It is quoted here. The concept of seniority cum merit in the matter of promotion postulates that given the minimum necessary merit requisite for efficiency of administration, the senior, even though less meritorious, shall have priority, and a comparative assessment of merit is not required to be made. While applying the principle of seniority cum merit for the purpose of promotion, what is required to be considered is inter se seniority of the employees who are eligible for consideration. Such seniority is normally determined on the basis of length of service, but as between the employees appointed on the same date and having the same length of service, but as between the employees appointed on the same date and having the same length of service, it is generally determined on the basis of placement in the select list for appointment. Such determination of seniority confers certain rights, and the principles of seniority cum merit gives effect to such rights flowing from seniority. For assessing the minimum necessary merit, the competent authority can lay down the minimum standard that is required and also prescribe the mode of assessment of merit of the employee who is eligible for consideration of promotion. Such assessment can be made by assigning marks on the basis of the appraisal of performance, on the basis of service records and interview, and prescribing minimum marks which would entitle a person to be promoted on the basis of the seniority cum merit. The principle of seniority cum merit being settled and made clear, thus turning to the case on hand, it is seen that the petitioner has scored 37 marks out of 50 in aggregate, which is more than the minimum necessary merit. The benchmark, that is 25 out of 50, fixed by the rules. Once persons are thus selected on overall performance as per rules, there is no scope of picking up persons for promotion, again on the basis of their comparative merit, as that would violate the principle of seniority cum merit. It is not in dispute that the promotions impugned have been given strictly on the basis of comparative merit of the selected persons shown in the result sheet. In view of the law laid down by the Apex Court as seen above, it definitely has violated the principle of seniority cum merit. Contention of the respondents that selection shall be the method of promotion on the basis of overall performance on three criteria: seniority, performance, and interview, is without substance and not acceptable for the reason that seniority and performance has been provided to be mode of selection in Appendix 3 of the said rules. A perusal of the relevant rules will further give the impression that seniority channel and merit cum seniority channel are the two modes of selection recognized by the said rules, and promotion from assistant grade 2 to assistant grade 1 falling in seniority channel only. The merit cannot be allowed to prevail over seniority when senior incumbents are found to have minimum necessary merit. In view of the above legal position, the promotion order impugns promoting 14 private respondents, superseding the petitioner who is admittedly senior to them, is ultra vires of the rules of seniority cum merit, and therefore the same is liable to be set aside. Lordship, some lines are missing.
Which page?
Page 37. Lordship, anyway, the result sheet prepared for promotion containing 36 incumbents, being not under challenge and having no infirmity, remains valid and shall be the basis for promoting the senior incumbents who have been left out, though they obtain the benchmark reflecting the minimum necessary merit provided in the rules. Thus, all the 36 persons in the said list having scored minimum benchmark, their comparative merit thereafter shall be ignored, and their seniority shall be the only criteria for promotion. In other words, promotion of those in the list who came within 15 positions in terms of their seniority need not be disturbed. Promotions of others of the said list who are juniors so cannot be accommodated within 15 vacancies stand quoted. Promotion of the petitioner and other seniors, if any, coming within 15 positions shall be retrospective from the date of the juniors. From the date the juniors have been promoted by the impugned order, respondents shall complete this exercise within the period of 2 months from today. Lordship, this is the law which has been settled by this honorable court in by taking the aid of the judgments rendered by the Supreme Court in those cases. And Lordship, the very bank, that is the Apex Bank, which had considered the merit of the petitioner vis-a-vis the private respondents on the basis of the performance, on the basis of performance even in the interview, and the seniority, or the marks obtained in the seniority, or on the basis of seniority. That is only for the purpose of seeing whether the senior has crossed over the benchmark. Once he has crossed over the benchmark, then it is no longer necessary to assess the comparative merits on the basis of all those performance and other things. So, what has been stated here in this particular case is that 50% out of 50 marks, 25 marks was the benchmark grade. And even here, and the rules that we have read out, it is 50%, that is the required minimum qualifying marks, that is the benchmark. And in spite of that, the petitioner has been superseded by the respondent number 3. We cannot say that the respondent number 4 has superseded the petitioner because the respondent number 4 is at a higher level in the inter-se seniority. If I take a lordship to the inter-se seniority at page 39.
That's okay, Mr. Ramzao. At this stage, we'll issue notice.
Lordship.
We'll examine this aspect.
Oblige, Your Lordship. I have an interim prayer, Lordship.
That will be subject to the outcome.
Lordship.
That observation will be there.
Okay,
If they can file the affidavit at an early date, we can take it up for final disposal.
right. And the petitioner is on the verge of superannuation pension in the
When?
month of October.
October,
October this year, Your Lordship.
or even if he or she,
She could have been
So-
accommodated, Your Lordship.
no, that is a different thing. Now, supposing if she succeeds ultimately,
Right.
and she's already retired by the meantime, then post-retirement benefit
That's true. That's
can
true.
also be considered, isn't it?
Yes.
The promotion happened in July only.
July, yes. They've joined instantly, and then so far as respondent number 4 is concerned, we have not so much of a grievance, except for the consideration of the ACR, which was beyond the permissible limit, that is, which was submitted after a period of 3 months.
What is that ACR? Which year?
ACR of 2021-22. I've stated that in my representation, my appeal at page 52, Your Lordship.
How many years ACR was required to be considered?
5 years,
5 years. Okay. Now, what is AG? AG means assistant grade.
assistant grade.
And
Yes,
JMG will be junior management grade.
yes, Your Lordship.
Okay. Please write down. The promotion of the private respondent numbers 3 and 4 from the assistant grade to the junior management grade in the Mizoram Cooperative Apex Bank. White notification dated 23/7/2024, bracket annexure 12, has been questioned by the writ petitioner. Stop. The contention of the petitioner is that promotion can be made by 2 methods. In terms of the relevant provisions of the Mizoram Cooperative Apex Bank Limited Staff Service, bracket, amendment, close bracket, rules, comma, 2024, open bracket, rules of 2024. Stop. The first criteria is by way of merit cum seniority, and the other criteria is by way of seniority, comma, performance, etc. Stop. According to the petitioner, she is senior to the respondent number 3, and having secured the aggregate qualifying marks comma, promotion ought to have been given to her on the basis of her seniority position. Stop. In this regard, the earlier decision of the coordinate bench of this court in WPC number 55 of 2006, bracket Sri P. C. Lal Chanpuya versus the Mizoram Cooperative Apex Bank Limited and 18 others, close bracket, white judgment and order dated 11/9/2007, bracket annexure 6, has been relied upon. Stop, next para. In respect of the respondent number 4, comma, according to the petitioner, although she is senior to her in the seniority list, but the fact remains that one of the ACR, which is for the year 2021-22, to be considered for her promotion, was not submitted within the prescribed time limit of 3 months by the respondent number 4. And therefore, comma, the same could not have been taken into account by the authorities concerned in recommending her to be promoted to JMG. The petitioner is also said to be on the verge of retirement, with hardly a month left for her to be in service. Stop, next para. I've heard Mr. Sheila Ramzao, learned senior counsel, assisted by Mr. JML Somzola, correct? Wansong for the petitioner. Stop, issue notice, the motion returnable by 4 weeks. Mr. Silal Fagzwala, learned standing counsel, Mizoram Apex Bank, accepts notice on behalf of respondent numbers 1 and 2. And therefore, no formal notice will be required to be served upon the said respondents. Stop, the petitioner shall, however, furnish requisite copies of the writ petition to the learned standing counsel. Stop. Petitioner shall take steps for service of notice upon the respondent numbers 3 and 4 by registered post with AD due within 4 days. What about Dusty?
Dusty also
It will be in
possible?
your interest so that, you can. Additionally, the petitioner is permitted to serve notice to the respondent numbers 3 and 4 by way of Dusty within 10 days. And thereafter file an affidavit as proof of service. List the matter again after 4 weeks. Stop, having regard to the projection made by the petitioner. It is provided here, it is provided that the promotion made to the private respondents from the post of AG to JMG shall be subject to the outcome of this writ petition.
Your Lordship may allow me to file my affidavit in opposition after 3 weeks.
In that case, we'll make it returnable by 3 weeks.
Or 4 weeks, 4 weeks. Yes. I thought it is written 3 weeks.
There's no permission required for that.
Malum.
That's your right.
And if Your Lordship may allow me to file my power next week.
You file it.
Mala.
No orders required for that.
Mala.
Fine.
Orders, item number 5.
Give him back. You take back the book. Or you want to leave it here in the file?
Lordship, I'll furnish it as and when required.
Okay, take it back.
Lordship, this application for condemnation delay, there are certain things, for which I need to file additional affidavit.
This is your application.
Yes, Your Lordship.
They have filed objection. Now you want to file another.
Additional affidavit, Your Lordship.
Why? Why is that?
Because the manner in which the delay has been condoned, sought to be condoned, there are certain lacuna as far as I could understand. So, Lordship, some things that need to be said have not been said properly. Before any hearing is conducted on that.
Why? The written objection was an eye opener or what?
Not so much, not so much.
All right, Mr. Lianshima, will grant
My
that.
lord, let
How
them
much
be given-
Let the matter be posted after vacation, Your Lordship.
After vacation?
My lord, that will be too long. The matter has been pending for quite some time. I pray the matter be listed on 30 or 1st October, my lord, for final hearing on the application, my lord.
So,
Additional affidavit can be filed within a week. So they are
No,
going to
it
give
might so
more than
happen
10
that
days.
you may want to file another further objection.
I may not, my lord. I'm thorough about the facts of the case.
Can I record that?
Yes, my lord.
Okay,
I'm too sure about it.
Mr. Sila Ramzao Lanet, Senior Counsel, submits that he may be given some time to file an additional affidavit to support the interlocutor application submitted by the applicant, since some facts which are crucial for consideration by this court has not been incorporated. Stop, Mr. L.H. Liantrima, learned senior counsel appearing for the opposite party, on the other hand, submits that he has filed the written objection and there's urgency in the matter. Stop considering the submissions made. Let the matter be listed again on 1st of October. The applicant may file the additional affidavit on or before 30th of September 2024.
all right.
Right.
Item number 6.
May I please, Your Lordship? Lordship, this is an application for condonation of delay. There's a 686 days delay in filing the connected regular first appeal. And the reasons being is that, Lordship, the state government has taken steps and was within time. It was actually due to the fault of the present government advocate that there was some delay.
Ms. Malswamy,
Yes, Lordship.
we had adjourned one matter
Yes, Lordship.
because you are on leave, but you are available for this case.
Yes, Lordship. I'm sorry to say that I was to mention that that item, but however, I was at that point of time I was a little bit busy with the baby, so I couldn't mention it.
Okay,
And
now,
this,
okay. Now, what is to be done with this case?
Lordship, I think the respondent has already filed their objection.
Yes,
And,
the delay is for how many days?
686 days,
Okay.
Lordship, and the government has taken time. They were on time, but however, the delay was made by the present government advocate, Lordship.
Can it be heard today?
It was made by me.
Lordship, since my senior could not appear today, so he wants to make objections orally. So if this matter may be listed after a
No,
week or
you
so.
have made your objection in writing already, isn't it?
Yes, Lordship, but my senior, he wants to make objections orally again, it seems.
When do you want it?
After a week or as per the convenience of the court, Lordship.
Yes, what do you say? Miss
Lordship, there's an execution case pending in the district court in Lunglei district. So the government even they've been pressurizing me. So I know I've been on maternity leave, but however, Lordship, there's some urgency in this matter.
Okay, we have accommodated you in one case, so we'll accommodate them in this case.
Yes,
But
Lordship.
not for a long time. They say the 1 week, so we can have it next week.
Yes, Lordship. Lordship,
The parties have filed their respective pleadings in the instant IA, and they submit that the matter can be heard. However, a prayer for adjournment has been made on behalf of Mr. Joseph N. Lunglei, learned counsel who appears for the sole respondent.
Yes, Lordship.
So, as prayed for, let the matter be listed again after a week.
Yes, Lordship.
Yes.
Oblige.
Item number 7.
Lordship, we have filed this IA for the purpose of direction to the respondents to release payment of the running bill in respect of the work that has been accomplished.
Where is the bill?
Bill, we have not submitted, Your Lordship, but there is this bank authorization at Annexure 1.
What is this authorization?
This is for the purpose of payment to be made.
What is the arrangement now? Main writ petition. How is the work allotted to you? Relevant work order or
Yes,
the
Lordship.
allotment of the work to you?
There's an agreement. Before that, at page 50, Lordship will see the letter of acceptance for construction of playground at Tuipui Bari, Tuirum Dapcho, New Mamit,
This is
Rajiv.
addressed to the petitioner
Yes,
by the senior executive engineer.
yes, Your Lordship.
Now, what is the amount,
The
estimate cost?
amount is rupees 2 crore 30 lakhs 5,278.
And this construction is to be completed by what time?
12 months as per para 6.
12 months.
12
So,
months.
how much have you completed now?
Your Lordship, the work has been split. And in fact, out of this sanctioned amount, the subsequent sanction was made. Subsequent sanction was made at page 92, Your Lordship will see. 91.
91.
Yes. 91.
This is the impugn order.
This is the impugn order.
And you are
Order
at serial
dated
number,
7-3.
you are at serial number 1
Yes,
under column B.
yes, Your Lordship.
Has been split to what?
The amount has so much reduced. It has been reduced to 80 lakhs only
From?
from the original sanction, that is 230 lakhs. 2 crore 30 lakhs. It has been reduced to 80 lakhs.
2 crore 30 lakhs.
Yes.
And
in-
what is this 2 column? One is AA, accorded,
Yes. First column is the administrative approval
accorded
accorded.
for 245.
Yes, 245.
And
Then expenditure sanction concurred,
130.
130,
Lakhs,
130 lakhs.
130 lakhs, isn't it?
And yes, revised expenditure sanction, that is 80 lakhs. But in spite of this, Your Lordship, we have been allowed to work for an amount of 125 lakhs. So we have completed the work so far as 125 lakhs has covered. So a bill was submitted, and the executive engineer concerned is saying that as long as the case is pending, we cannot release the payment.
Okay.
What we have said here is
No,
that
Mr. Ramza, one question. See, AA accorded is 245, then ES is 130, then the revised estimate is 80.
yes,
But the work which has been given to you, letter of acceptance is, this is your quoted amount,
this is the quoted amount which has been accepted.
230.
Yes.
So ultimately, how much is your, okay, your,
It's only 34.78% of the original agreed amount.
after the passing of the impugn order?
After passing of the impugn order.
Okay.
So far as 80 is concerned,
So although 80 is reflected here, you have worked up till 125.
125.
Okay. And where is your bill?
Lordship?
Your bill. You
Lordship,
said you have submitted your bill.
it's in the department. They have prepared and they have not served a copy to me.
So what is
So,
available
at the
in
same
your
time,
IA?
This bank authorization at page 7 of the IA, it says that the executive engineer, PWD project division, ISOL, is hereby authorized to draw a sum of 215.4 lakh rupees, 15 lakh 40,000 only from Mizoram PWD SESCI fund account number so and so, for execution of works under SESCI as mentioned below. And the work in respect of the petitioner is at serial number 2. And here it says construction of playground at Tui Bari, Tui Room, Dapcho, New Market, New Mamit, Rajiv Nagar 1. So for this, 125 lakhs has been said to be amount payable. So this has been obtained. It is now in the custody of the EE concerned. But he is not in the mood of releasing it, simply because the case is pending.
Where's your statement to that effect? RA bill means what?
Running account bill,
Running account bill.
yes. In para 2,
But when did you submit your RA bill?
RA bill we had submitted immediately after this bank authorization was obtained.
You should have made a specific statement here.
We did not, Lordship. That's a mistake on the part of the petitioner.
Ms. Lalnun Louis, what is your instruction?
Yes, Your Lordship, as per my instructions that I received in the morning, Your Lordship, the main contention was that the bill has not been submitted till date. The quoted RA bill, so it has not been submitted, Your Lordship. And with regards to the...
But they say RA bill is submitted in their application.
Yes, Your Lordship, we will have to verify it as well, Your Lordship. And further instructions are being awaited as well.
No, you can very well, we can ask them to submit, if not already submitted, and you verify them, then pay them,
Yes, Your Lordship.
isn't it? Why should we keep this thing pending like that? We're not saying them you pay them blindly. We're giving you an opportunity to verify
Yes, Your Lordship.
the bills. If not submitted, they will submit, and you verify them. And if they've actually performed the work, you pay them.
Yes, Your Lordship.
And otherwise, this writ petition is filed for the, what do you call it? Because of the splitting.
Without
Because of the splitting of the work. There were many cases, I think, which you have filed
Yes,
similar.
yes.
What has happened to those cases?
It's still
Not yet finalized.
not yet finalized, and no Paraguay's comment has been received by them. That's
Then, in the meantime, what has happened to the work? You have
the
stopped
work.
or
The
you're
work
still going on?
so far as the sanctioned amount, the reduced sanction amount, up to that we have completed, and in those other cases, payment was made.
Okay, payment made, the reduced amount of work completed.
And we are waiting for the final outcome of this writ petitions.
What about the remaining work?
Remaining works are
It's
still
suspended.
awaited. It has not been
It is suspended.
suspended.
Hanging.
Yes.
And what are these works normally? I mean,
These are construction of roads.
roads and
roads,
playgrounds and all that.
yes, Playgrounds.
But how can that remain like that?
Because in the impugned notification, in impugned order, they have reduced the amount so much. In some cases, they have reduced it to 30, in some to 50, and the manner in which they have dealt with the matter does not seem to be in consonance with the agreement which they have signed.
That is one point which you're raising, but the thing is that what about the interest of the public? When the work is being executed, half work done, half work remaining,
Right.
how long we will remain like that?
There was, in connection with the other cases, this honorable court had given a direction that the matter should be, affidavit in opposition needs to be submitted immediately, and it is still now pending in the finance department. The ENC had stated that they have prepared all the Paraguay's comment and they had submitted it to the finance department, and finance department had not responded as yet. That's what they said.
So we'll dispose this IA then.
That's it.
They'll verify, and if it's found to be okay, correct, should be released. Please write down. Heard Mr. Silo Ramzao, learned senior counsel, assisted by Mr. J. Malsom Zola Wansong for the applicant, and also Ms. Lalnun Louis, learned government advocate, appearing for the state respondents. Stop by filing this application. The applicant stroke writ petitioner seek for a direction to the respondent authorities concerned to release the payment of the pending bill amount of rupees 125.90 lakhs to the applicant for having completed the portion of the work allotted to him, that is, i.e., construction of playground at Tuipui Bari, Tui Room, Dapchua, New Mamit, and Rajiv Nagar - Roman 1. The learned senior counsel submits that the petitioner, for having completed How much have we completed?
It is more or less 50% of the total agreed amount.
50% of 80 lakhs.
No, 50% of 230 lakhs.
Oh. Having completed about 50% of the work originally allotted to him. Submitted his running account bill before the, which respondent? Respondent authority concerned.
Yes, Your Lordship.
And following the same, the engineering chief PWD Mizoram on 13/6/2024 issued a bank authorization for SASCI, SASCI, for an amount of rupees 215.4 lakhs, and out of which the pending bills of the petitioner, that is rupees 125.90 lakhs, is also included. Stop. However, in view of the pending writ petition, pending connected writ petition, the learned senior counsel submits that the respondent authorities are reluctant to release the said amount to the applicant. Stop. He therefore submits that the respondents may be directed to release the amount pending final disposal of the writ petition, since the amount is for the work already executed by the applicant.
Executed and satisfactorily completed, Your Lordship.
Executed and satisfactorily completed by the applicant. Stop. He also submits that release of the said amount will not be an impediment to consider the connected writ petition. Next para, Ms. Lal Nunclui, learned government advocate, on the other hand, submits that as per the instructions received by her, the petitioner, the applicant has not submitted his bills. And she also submits that pending further instructions from the respondents, she may be given some more time to respond to the interlocutory application. Stop. Next para. It may be noted herein that challenge made in the writ petition by the petitioner is to the splitting of the work allotted to him by the, no, allotted to him to no, splitting of the work allotted to him, the rest you cut, allotted to him, and thereby reducing the same to about 34.78% of the initial value of work. By issuance of the impugn order dated 27/3/2024. Stop. According to the petitioner, as per the revised estimate, the petitioner has been, the work value of the petitioner, the work value of the work to be executed by the petitioner has been scaled down to a sum of rupees 80 lakhs. But nevertheless, the petitioner has been allowed to proceed with the work. Beyond 80 lakhs, and that the petitioner has, the applicant has executed works up to the value of rupees 125 lakhs.
0.9.
0.90, 125.90 lakhs. To stop such being the position, the petitioner has sought for release of the said amount. Stop. The bank authorization for Saski dated 13/6/2024 issued by the Engineer-in-Chief PWD Mizoram has also been annexed by the applicant in the application as Annexure 1, wherein authorization has been given for drawal of rupees 215.4 lakhs, which admittedly includes the pending bill worth rupees 125.90 of the applicant. Stop. Such being the case, this court finds no impediment in directing the respondent authorities to release the amount due to the petitioner, to the applicant. Stop. Next para. The application is therefore disposed of by directing the applicant to submit his regular, what do you call that? RA bill?
RA bill.
Running account bill. Before which respondent?
Before the respondent,
You have up till SE only.
SE. In fact, the amount is deposited with the
E.
EE.
You should have made E a party also.
EE of Project Division 2 ISO.
They are not a party here.
He's not a party.
Is he a party in the writ petition?
No.
Then,
He has been authorized to draw and make payment.
where are you supposed to submit your bill otherwise?
I can submit my bill to the EE concern. That is the one who is looking after the work.
Who's that?
Executive Engineer, PWD, Project Division 2, ISOL.
What did I say? Last line. Senior Executive Engineer, PWD, Project Division, Roman 2, ISOL. If not already submitted within a period of 10 days from today,
Your Lordship,
Yes, Your Lordship.
10 days.
stop. Upon receipt of the RA bills, the respondent authorities concerned will be at liberty to verify the same as per the records and to ascertain whether the works have been actually completed or not. Stop. If the
Your Lordship, the manner in which the bills are submitted is that after proper verification, the unsatisfaction of the concerned officer, then RA bill is prepared by the authority concerned, and then it is, processed and paid.
correct, I am aware of that, Mr. Ramzao, but we'll give them that liberty to once again look into it.
All right.
And upon such verification, if the bills are found to be correct, the amount due to the petitioner applicant shall be released within a period of
1 week, Your Lordship. It has been kept pending for so long.
Within a period of 1 week of completion of the said verification. Stop. The respondent authorities should complete the exercise of the verification of the bills expeditiously and at any rate within a period of 3 weeks from the date of receipt of the RA bills. And oblique or, even if the RA bills have already been submitted by the applicant. I think that's all. Within 10 days, what did I say, 1 week or 10 days?
10 days.
10 days you
Submit it
submit
within
your
10
RA
days.
bills, if not
Yes.
already submitted.
Right.
Within 3 weeks, they'll examine, they'll verify, and
And we
within
have
1
said
week,
that
they'll
we have
release.
submitted it already. And if it is submitted, Your Lordship, within 3 weeks, matter will be
Yes.
disposed of.
Even if it's already submitted, or if you have to submit also, within 3 weeks, they'll verify, and within 1 week thereafter, they'll pay you.
Right.
All right? Okay.
Obliged, Your Lordship.
So this was item 7. What about the writ petition? What is the stage?
Stage, Your Lordship, no affidavit has been filed.
Your
with
Lordship,
the-
How much?
2 weeks' time may be granted, Your Lordship, because the paragraphs comments have been submitted for vetting, Your Lordship.
2 weeks is sufficient.
Yes, Your Lordship.
Okay, as paid for by Ms. Lalnun Lui, learned government advocate, appearing for the state respondents. Further 2 weeks' time is granted for filing counter affidavit. This will be in the writ petition. Okay. The other one was in the IA. Okay, then what remains? 2, 3, 4. Who are there in this case?
Lordship, item 4, if I may.
Yes.
Item 4, Your Worship, this is a petition for quashing the criminal proceedings initiated against the petitioner. And service of report on respondent, the private respondent was awaited. It is complete. My learned friend is appearing on behalf of the private respondent. And they have filed an MACT claim. So there are talks of compromise regarding that MACT claim. So this matter may come after the vacation.
No objection, my lord.
So what can we record here?
Let the matter be today. Since this is the first time respondent number 6 has appeared, he may be given time to file the
Yes.
affidavit, if any.
Give me the file. You're for respondent number 6.
Yes, my lord. I'm appearing on behalf of my senior, Mr. Zoram Chana, counsel for respondent
your
number
submission?
6. Lordship, I'm seeking 3 weeks' time because we haven't received any the criminal petition from our clients yet.
You serve them?
Yes, Your Honor.
Your good name, please?
Lalring Zola Colony.
Mr. Lalrin Zwala Colony, learned counsel, submits that. Who is your senior?
Zoram Chana.
Okay. Submits that Mr. Zoram Chana, his senior, has instructions to appear for the respondent number 6. And therefore he prays for,
3 weeks' time.
what about power? When will
Lordship,
you file?
We have already filed.
You filed already?
Yeah,
When? Okay. And prays for 3 weeks' time to file a reply to the objection to the criminal petition. Stop in view of above, the notice upon respondent number 6 is complete. Matter stands adjourned for 3 weeks to enable the respondent number 6 file objection. Petitioner to serve a copy of the criminal petition to the respondent number 6, counsel for respondent number 6. Yes. This 2 and 3 can be heard. Who is there?
Regarding item number 3, my lord, I'm for respondent number 5. And if I may be granted some further time to submit a counter affidavit.
Item 2.
Item 3.
3.
Yes.
You are appearing for
Respondent number 5.
5. Mr. Lianchima?
I'm for the petitioner, my lord.
Okay, parties are represented by the respective counsels.
For respondent 1 to 4, my lord.
On the prayer of the counsel for respondent number 5. What about state? Have you filed?
Yes, my lord. No, not yet.
On the prayer made by the learned counsels for the respondents, further 3 weeks' time is granted for filing affidavit of opposition. List again after 3 weeks.
Obliged, my lord.
Obliged.
Item 2.
Yes, Lordship. I'm appearing on behalf of Mr. Patak. He has requested me. Earlier, this petition was dismissed. However, it was restored by CMA application number 1 of 24.
Okay. So,
Yesterday, it was fixed date. So, Mr. Patak could not make appearance for today. He's having scheduled item in Shillong. So, we haven't received a copy of affidavit in opposition filed by the state.
state you have filed? Have you filed?
They have filed from previous.
My lord, the matter is being handled by Miss Mary, and I have checked the file last week, and it has not yet been filed.
State is respondent numbers.
One.
Number 1 to 5.
This is the affidavit. It is as thick as the writ petition.
But it's not there in the file, my lord.
So what to do?
Maybe this matter is being handled by Miss Mary, so it must be in our home, in our residence.
You don't have a copy.
Yes.
And a prayer for adjournment has been made on behalf of Mr. B. Pathak, learned counsel for the petitioner. on the ground that he has some personal difficulties to appear before the court today. You're not there in this case.
No, my lord. He has requested me.
Okay. Ms. B. Lal Nemi, is it?
Lalram Nemi.
Ms. B. Lal Ram Nemi, Learned Counsel. No, cancel the order. Ms. B. from the beginning. Ms. B. Lal Ram Nemi, Learned Counsel, submits that Mr. B. Pathak has some personal difficulties to appear before the court today and prays that the matter be adjourned and be listed on a convenient date.
If it can be fixed, my lord.
She also submits that the affidavit in opposition filed by the state respondent, numbers 1 to 5, has also not been served to the petitioners. When do you want it?
18 of next month.
In view of above, let the matter be listed again on 18th of October 2024 as paid for. A copy of the counter affidavit filed by the respondent, numbers 1 to 5, be served upon the counsel for the petitioner in the meantime.
Oblige.
That's all.